everyone, my name is Lalit Soni and you are watching UPSC Prelims PYQ analysis series by Drishti IAS. Now in this episode, we will be talking about the another PYQs from the Polity section. We have come up with the first episode of Polity wherein we have discussed some of the part of the constitution and some other related aspects over there. And then now today we will be talking about the union executive and some part of state executive, legislature, etc. So let's start our discussion. There will be another part for that. We will be discussing the judiciary and the local self-government and the you can say bodies like constitutional bodies and the non-constitutional bodies. So as we told you that we will be starting from 15th of February, we will be starting this series wherein we will be discussing the PYQs of last 6 years, okay, that is from 2019 to 2024. So we have come up with this series. If you have not watched the first episode, go ahead and watch that. That is available on our YouTube channel. There is a playlist that is UPSC Prelims PYQ analysis by Drishti IAS. So you can go through that particular playlist and you will find the videos over there. So in this series, what we are doing is that we are basically going through the PYQs of last 6 years, and we will tell you that how these are important, from where UPSC is asking questions, what are the core areas. So that is why this particular series will be important for you, okay. Other than that, whatever discussion we will be doing over here, okay, so this particular PDF will be uploaded on our Telegram channel. So link is given in the description, so you can get the PDF from there. Other than that, there will be one question in the comment box which will be pinned for you. That is a mock question, so you have to attempt that after the discussion so that you will be knowing that what you have learned till now, okay. So that is about it. So every day we will be meeting you at 9 PM in the evening, and you will be together we will go for the PYQ analysis, okay. So let's start with the second episode. Herein we are talking about the some of the part of the, you can say, legislature and the executive, okay. Starting with the first question, that is related to union executive and legislature. So let's see. As per Article 368 of the Constitution of India, the Parliament may amend the provisions of the Constitution by the way of addition, variation, repeal. Select the correct answer using the given code below. Now they are talking about the amendment. They are talking about the Article 368. Okay. Now there are different ways to amend the Constitution, which you should know. There are 3 ways in which Constitution can be amended. Now this is a hint by UPSC that they might ask you about that. Okay. So this is the question which has been asked in 2024. So now it is your duty that you will go and check in how many ways we can amend the Constitution. Okay, so that is there. First is basically with the simple majority. There are some provisions which can be amended with the simple majority. You don't have to go for the constitutional amendment. Then coming to the second way, that is through Article 368, you will be requiring special majority. Okay, so that is there. And there is this another way which is related to the federal features. If you are going to change the federal feature, you will be requiring special majority in the parliament as well as 50% ratification from the states. So these are the ways through which constitution can be amended. Okay, so when we talk about the amendment, so addition, variation, repeal, all of them are basically part of the amendment. So option D would be your right answer. Now here you can see Article 368 is in the part 20 of the Indian Constitution, which is dealing with the power of Parliament to amend the Constitution. Who has the power? Parliament has the power to amend the Constitution. State assemblies cannot go for the amendment. If there is a federal feature, in that case ratification by 50% of the state assembly will be taken. That is another part. But the thing is, power to amend the Constitution is with the Parliament. Earlier there was this debate whether Parliament has the power or not. Okay, we will be talking about that debate as well. Moving further, it states that the Parliament may amend the Constitution by the ways of addition, variation and repeal. So we have already talked about that. We have already seen this article which is given in the Article 368. Okay, the Parliament can amend the provisions of the Constitution but cannot destroy the basic structure of the Constitution. That is the doctrine which has been given in the 𝐏𝐻𝐿 𝐏𝐵 judgment in 1973. If you remember the date, that is 24th of April 1973. Okay, so that is about the 𝐏𝐻𝐿 𝐏𝐵 and the basic structure doctrine. Okay. Now, before moving further, what I want to tell you is that we are going for the PYQ analysis. We are going for the questions over here. So I'm assuming that you will be having some basic knowledge, that you have gone through the syllabus once. Okay, even if you have not, you have some understanding that how Constitution is being you can say amended. So I will not go into details of the static part over here, but I'll be focusing more on the PYQs. Okay, so coming to the next thing, that is the doctrine of basic structure. Now when we talk about the doctrine of basic structure, as I told you, there was this debate that who can amend the Constitution and which part of the Constitution can be amended. So When we talk about the which part of the constitution, the answer is that you can amend anything. Parliament can amend anything, but it cannot destroy the basic structure. Now, who will tell what is the basic structure? So that will be told by the Supreme Court. Supreme Court in various decisions has said that this is basic structure and this is not. Okay. So here you can say 𝐤𝐴 Bharati. When we talk about the idea of the basic structure, that was originating from the German constitution. Okay. If you can remember, well and good. Okay. Now coming to the landmark judgment, that is 𝐤𝐴 Bharati case 1973, which we have already seen, that has introduced the phrase basic structure of the constitution. Okay, that was the phrase which was first used after the 𝐤𝐴 Bharati judgment. Okay, coming to the next part, what are the constituent of the basic structure? Every time court by the various decisions and judgment, they will be telling you that this is the you can say basic structure and this is not. So here, supremacy of the constitution, parliamentary system, free and fair elections, independence of judiciary, limited power of parliament to amend the constitution. When they are saying that limited power, that means that they cannot destroy the basic structure of the constitution. Okay, powers of the Supreme Court under Article 32, 136, 144 and 142, and then power of the High Courts under Article 226 and 227. Now this is not an exhaustive list. There is, you can say, there are various other things which can be added to this particular list. Okay, so that is the doctrine of basic structure. Now coming to the debate that who can amend the parliament, whether who can amend the constitution, whether parliament has this right or not. So this question was first raised in Shankari Prasad case in 1951. Okay, in that case, and afterward there was this another case, that is Sajjan Singh case, that was in 1965. In both the time, court has said that the Parliament has absolute power to amend the constitution under Article 368. Absolute power, everything you can amend. Okay, but then another case came, that was the Golak Nath case. Golak Nath versus State of Punjab. In that particular case, it was held that Parliament cannot amend the fundamental rights. Okay, Parliament cannot amend the fundamental rights, and this power rests only with the Constituent Assembly. When we talk about the wordings of the 368 at that point of time, that was Constituent Assembly. The power was given to the Constituent Assembly. But after, you can say, 1950, we did not have the Constituent Assembly, we had the Parliament. So in that judgment, it was said that the Constituent Assembly is different from the Parliament, and that is why Parliament cannot amend these fundamental rights. Okay, so that was there. Then coming to the next one, that is your 𝐤𝐴 Bharati case 1973. In that case, it was said that the Constituent Assembly, right now the Parliament is basically working as the Constituent Assembly, and it was said that the Parliament can amend anything. But the thing is, they cannot destroy the basic structure. The fundamental feel of the constitution, you can destroy that. You cannot destroy the philosophy of the constitution, but you can go for the provision which are needed some kind of change. And that is why we said that our constitution is a living document. With the time, you can go for the amendment. So that is there. Parliament could amend any part of the constitution, but cannot alter the basic structure of the constitution or the essential features of the constitution. And after that, that is the position. You will be seeing that in 1975, Indira Nehru Gandhi versus Raj Narayan. After that, there was this Minerva Mills versus Union of India. Then Vaman Rao versus Union of India. Indira Sahni versus Union of India. Then S.R. Bommai versus Union of India. These all cases has said that yes, we cannot destroy the basic structure. But in these cases, they have said that what becomes part of the basic structure. So when we talk about the Minerva Mills versus Union of India, you will be seeing that the judicial review, harmony between the fundamental rights and the DPSP is part of the basic structure. Okay, coming to the next one, that is Vaman Rao versus Union of India. They have said that the doctrine, that is the basic structure doctrine, would apply to the constitutional amendments enacted after the date of the judgment in the KB case. When we talk about the 𝐤𝐴 Bharati case, that will be, you can say, whatever constitutional amendment are there. So you can actually go and basically you can say that it is about the judicial review only. Doctrine would apply to the constitutional amendments as well. Okay. Coming to the next one over here, that is Indira Sahni versus Union of India. Here they have said that the rule of law declared as the part of the basic structures, that will be same for all. Then coming to the S.R. Bommai, here they have said that the federal structure which India is having, that is the part of your basic structure. So here federalism, secularism, democracy, unity and integrity of the nation, and the social justice were iterated as the part of the basic structure. So I hope that is clear. Now coming to the next part, before that I would like to tell you that how we are helping you in your preparation. IAS prelims test series are there. When we talk about PYQ, you know that what UPSC is asking. From there you will be finding the trends, but you have to practice new questions as well. You have to practice the current affairs related questions as well. You have to practice the static part as well. Okay. So what can be the probable questions? That has been actually taken care with the practice of the MCQs. And no other option is there better than the test series. So you can go for the IAS Prelims Test Series 2025. Key features as given over here. When we talk about the analysis over here, so we will be giving you detailed explanation, the comprehensive coverage of the whole subject that will be there. Subject wise evolution will be there, and detailed explanation will be there with that. So medium here is English. For more details, you can call on this number, that is 87501, or you can download the Drishti Learning app. Okay. Now let's move further to the next question. Which of the following statements are correct with respect to the money bill in the parliament? When we talk about money bill, you know that there are some articles like article 110 is talking about the money bill, etc. But the thing is, you need to understand that constitution has a scheme as well. What is the scheme? Before that 110, there is a procedure which has been given, and after that also when we talk about the finance bill, financial bill, these things are there. Okay, UPSC has this tendency to ask things from the differences, where is a little bit of intricacy is there, they will ask you that things. Okay, so let's see which of the following questions are correct with statements are correct with respect to the money bill in the parliament. So let's see. First statement is Article 109 mentions special procedure in with respect to the money bills. So here they are saying that with respect to money bill, procedure is been given in Article 109. Now the problem is that you might not know that, because we have already studied that 110 is the article which is related to the money bill. Yes, that is the article which tells you that what forms the part of money bill, like what kind of you can say provisions, if they are in the act, that will be a money bill. So that is basically given in the 110, and 109 is talking about the procedure. Okay, so that is there. Then after that, a money bill shall not be introduced in the Council of States. When we talk about the Rajya Sabha, so they are saying that money bill cannot be introduced over here. So that is also we will be considering. Hold on for the second, and then we will be considering that as well. Coming to the next one. Rajya Sabha can either approve the bill or suggest the changes but cannot reject it. Now we know that Rajya Sabha has limited power, so that is also that Rajya Sabha can actually basically suggest something, but they do not have power to reject it. Okay, they cannot amend the bill. Okay, so that is there. Coming to the next one, amendment to the money bill suggested by the Rajya Sabha have to be accepted by the Lok Sabha. Now this is, we are sure that there is no such binding thing. Rajya Sabha can only make suggestions. Now it is up to Lok Sabha that whether they want to do it or not. Okay, so we know that one thing is clear, that fourth is not your answer. Okay, now coming to the second other options, 1, 2, 1, 2 and 3 and 2 and 3. Now we have to see that which is the answer over here. The money bill shall not be introduced in Council of States. Okay, now that is also one thing which we know that Rajya Sabha does not have any power like that. So we can say that yes, this statement is correct. Okay, now we know that 2 is right. In all three options it is given. Now we have to see the statement number 3. The Rajya Sabha can either approve the bill or suggest some changes. Now if you look at this particular portion over here, okay, now this is the money bill. Article is 110, which we have seen that article is 110 where they have given, but 109 is where you have the procedure. Okay, now it can be introduced in Lok Sabha only, which we have already seen that because Lok Sabha has that power and Rajya Sabha has limited power. It is introduced by the ministers only. When we talk about the presidential you can say recommendation, that is also required over here. Now when we talk about the amendment or the rejection by the Rajya Sabha, here they can only recommend. Okay, they cannot do anything. They that recommendations are not also binding. Okay, now so this is about your recommendation over here. Only Rajya Sabha can recommend this, and they will not be making it binding on the Lok Sabha. Okay, so coming back to the question over here. So now the money bill shall not be introduced in the Council of State. We have seen that Rajya Sabha can either approve the bill or suggest some changes but cannot reject it. That is what I have told you, that they can approve the bill or they can actually suggest some changes but cannot reject it. They do not have that kind of power. So now this statement is also correct. We have already seen that fourth one is not. So 1, 2 and 3 is correct. So option C would be your right answer over here. Okay. Now let's see the other part. Now there is one intricacy which is there. If you do not know this, that article 110 is talking about the money bill, but you should know that if there is a nearby article like article 109 or 111 they are asking about, so logically thinking you can say that there might be a chance. Okay, now if you have to take a risk out of these two things, 1, 2 and 3 and 2 and 3, so you try to take this risk smartly. You have to guess smartly over here. Okay, coming to the discussion over here. Article 109 of the Constitution mentions a special procedure with respect to the money bill, which we have seen. Money bill must be introduced in the Lok Sabha and cannot be introduced in the Rajya Sabha. Rajya Sabha can only make recommendation, and these recommendations are not binding on the Lok Sabha. Amendment to a money bill suggested by Rajya Sabha, which can be rejected by Lok Sabha. Okay, so that is your answer. Now there are types of bill which is there in the, when we talk about the parliamentary procedures, there are different kind of bills which are there: ordinary bill, money bill, financial bill, and then constitutional amendment bill. When we talk about the ordinary bill, we know that these are daily basis when we talk about the legislative functions. So there are various matters which are subjected to the ordinary bills. Okay, these are other than the financial matters. Now when we talk about the money bill is concerned with the matters like taxation, public expenditure, regulation of borrowing of the money by union government, and consolidated and the contingency fund of India. Okay, so that is been given in article 10110. Okay, then financial bill, if we talk about, so you know that there is this article 117 which is there. So they are talking about that, concerned with the financial matters but different from money bill. They are also concerned with the financial matters but they are different from this particular money bill. Okay, there are two types which is there. Financial bill 1, a bill that contains borrowing clause but does not exclusively deal with the borrowing. Okay, so there is a mention of the borrowing clause but they are not dealing with the borrowing exclusively. Then financial bill 2, provision involving expenditure from the consolidated fund of India but excluding the matters mentioned in the money bill. Okay, so that is your financial bill 2. Okay, Constitution Amendment Act bill, which we have already seen that we have three types through which constitution can be amended. So that is there. Coming to the different bills over here, and different whatever the difference are there, distinctions are there. So when we talk about ordinary bill, it is mentioned in article 107 and 108. Okay, and when we talk about the money bill, it is 109 and 1010. When we talk about the financial bill, article 117 clause 1, financial bill 2, that is 117 clause 3, and constitution amendment, that is article 368. Okay, now when we talk about ordinary bill, that can be introduced in both Rajya Sabha and Lok Sabha. When we talk about the money bill, it is only introduced in the Lok Sabha. Financial bill only Lok Sabha. When we talk about the financial bill of second type, that can be introduced both in Lok Sabha and Rajya Sabha, and constitution amendment bill that can be introduced in both Rajya Sabha and Lok Sabha. Now it is introduced by who will be introducing it? So ordinary bill, minister or the private member can also actually go for the introduction of the you can say ordinary bills over here. Private members bills are those who are not, you can say, prepared and presented by the ministers. Okay, so that is private member bills. Then coming to the money bill can only be presented by the, you can say, only ministers. Financial bill 1, that can be presented by minister or the private member. Financial bill 2, that can be presented by the minister or the private member. Or when we talk about the constitution amendment, that can also be introduced by both minister or the private member. Okay, coming to the recommendation for ordinary bill, you don't require any kind of recommendation by the president. For money bill, you require a recommendation by the president. Okay, coming to the financial bill 1, so you will be requiring, you can say, the recommendation by the president over here. And when we talk about financial bill 2, only require consideration and not recommendation. Okay, so that is the thing. And when we talk about the constitution amendment bill, so you will not be requiring any recommendation from the president over here. Coming to the next part, amendments. So in the ordinary bill, Rajya Sabha can make the amendments. When we talk about the money bill, only recommend, but these are not binding on that. Financial bill, they can actually go for the amendment. For the financial bill second type, you can go for the amendment, and the constitution amendment bill, you can go for the amendments. Okay, then coming to the joint sitting provisions, if there is a deadlock that Rajya Sabha has actually, Lok Sabha has passed the bill and Rajya Sabha has not, in that case there can be a joint sitting which will be notified by the president. Okay, so in the ordinary cases, you can go for the joint sitting. When we talk about money bill, there is no such provisions because obviously Rajya Sabha does not have much power over here. So if Lok Sabha is passing the bill, that is considered as passed. So no provision of, you can say, joint sitting for the money bills. When we talk about the financial bill 1 and financial bill 2, for that joint sitting can be summoned by the president. And when we talk about the constituent assembly, the constitution amendment bill, in that case you will not be having a joint session because obviously the numbers will be more in the Lok Sabha, and considering that there will be a inherent disadvantage. Okay, so that is why there is no such provision for the joint sitting in you can say constitution amendment bill. I'm sorry. Anyways, moving further, president's role, if we talk about, so in the case of ordinary bill, he can reject, he can approve, or he can return for the consideration. When we talk about the president's role, here they are talking about the assent by the presidents. Okay, so that is there. Coming to the money bill, he can reject the bill, he can approve the bill, but he cannot send for the reconsideration. Okay, Then coming to the financial bill type 1, type 2, here he can reject, approve or return the bills. And when we talk about the constitution amendment bills, in that case he must approve, he does not have any power to reject or return. Okay, so this is the type of bill which we have discussed. Now if there is any question which has been asked by the bills, this is the table which can be important for you. Okay, so you can take the screenshot, or you can take it from the PDF itself. Okay, now let's move further to the next one. Consider the following statements. A bill amending the constitution requires a prior recommendation of the President of India. Here we have seen the constitution amendment bill over here. So recommendation, that is not required. Okay, so this statement becomes incorrect over here. Now once you eliminate this statement, you will be seeing the options that only one option is possible, that is option B. Here you can see answer is option B. Then coming to the next statement, we will be reading the statement, no doubt. When a constitution amendment bill is presented to the President of India, it is obligatory for the President to give his or her assent. Now this is correct, because in this particular aspect over here, we have seen that what is the role of President over here. When we talk about the constitution amendment bill, must approve, there is no other option. Okay, so that we can say that statement 2 is correct. Coming to the third one, a constitution amendment bill must be passed by both Lok Sabha and the Rajya Sabha by a special majority, and there is no provision for joint sitting. We have already seen over here that joint sitting is not allowed for the constitution amendment bill. Okay, so I hope that is clear. So we can see that option that is B, 2 and 3 is your right answer over here. With that, when we talk about the statement based question, you will be seeing that sometimes UPSC has this tendency that with one particular statement, if you know that particular statement, you will be able to eliminate the other ones. Okay, so when you see a question which is kind of difficult, just don't lose hope, just read the question. If you know only one statement which you can eliminate, there are high chances that you might be able to get the answer. Okay, now coming to the next part. Consider the following statements. The President of India can summon a session of the Parliament at such places as he thinks fit. Okay, so that is true when we talk about the summoning the Parliament, and you can say prorogation, etc. So President has the power. Okay, the Constitution of India provides for the 3 sessions of the Parliament in a year, but it is not mandatory to conduct all the 3 sessions. Now the thing is, there is nowhere in the Constitution it was written that you have to go for the 3 sessions. What is written is that within one session, in the second session, there should not be a gap which is more than 6 months. Okay, more than 6 months of the gap should not be there between the 2 sessions. So we can say that this statement is wrong, because Constitution does not say that there should be 3 sessions, but conventionally we are having 3 sessions. Okay, there is no minimum number of days that Parliament is required to meet a year. Now again, there is no minimum number of days which is mentioned, so we can say that this statement is true. So if you look at the options over here, 1, 2, 1 and 3 only, and 2 and 3. So second one was wrong. So 1 and 3 would be your answer. That option C would be your right answer. Okay, so that is given over here. Article 85 of the Indian Constitution talks about the summoning of the Parliament, House of the Parliament over here. So here, President is entitled to summon each house of the Parliament to meet at such time and place as he thinks fit, but 6 months shall not intervene between the last sitting in one session and the date of the appointment of the first sitting of the next session. Okay, so basically they are saying that in the 2 sessions there not be a gap more than 6 months. Okay, then moving to the next one, by convention we are going for this is not provided in the Constitution. Again, I told you that there is nowhere it is written that you should have 3 sessions. By convention we are having 3 sessions a year. First is the budget session, which is the longest one, where second is the monsoon session after the budget session, and then we have the winter session. Okay, so that is there. Coming to the next one, there is no minimum number of the day that Parliament should meet, that has been written over here. So that is your option C, which is your right answer. Moving further. With reference to Union Budget, consider the following statements. Union Finance Minister on behalf of the Prime Minister lays the annual financial statement before the House of the Parliament. Now, annual financial statement, that is mentioned in Article 112, that is generally known as budget, but the term budget has not been used in the Constitution. Okay, so please remember that the term budget has not been used in the Constitution. Similarly, when we talk about the term office of profit, now this particular term has been mentioned in the Constitution, but the thing is it is not defined. Okay, so such things can be asked by UPSC. Okay, earlier also UPSC has asked such questions. Or when we talk about the term that is cabinet word has been used in the constitution, but it has not been defined anywhere. Okay, so like that you should remember that this office of prophet, cabinet, council of minister, or the budget, all these things you should know. Okay, so when we talk about this one, union finance minister on the behalf of prime minister, no, on not on the behalf of prime minister, but on the behalf of president. Okay, so that statement is wrong. At union level, no demand for grant can be made except on the recommendation of the president. That is right, which we have already seen in the money bill etc. as well. Okay, so we can see that for that recommendation is required. So statement 1 is wrong, statement 2 is correct. Option B would be your right answer over here. So let's see, union finance minister on the behalf of president and not prime minister. So that is correct. Coming to the next one, article 112 of the constitution is talking about the president shall, in respect of every financial year, cause to be laid before both house of the parliament a statement of estimated receipts and the expenditure, whatever from where money is coming and where money is going out, that kind of estimate of the government of India for that year, referred as the annual financial statement, which we generally called budget. Okay, so that is important for you. Article 113 of the Indian Constitution, at union level, no demands for grant can be made except on the recommendation of the president. So that is also correct. Coming to the next part, along with the budget, the finance minister also place other documents before the parliament, which includes the macroeconomic framework statement. The aforesaid document is presented because it is mandated by long-standing parliamentary convention, article 112 and article 110 clause 1 of the constitution, article 113 of the constitution are provisions of the fiscal responsibility and the budget management act, that is FRBM act. So option D is your right answer. Along with the budget, there are 3 documents which are basically presented in the parliament. Okay, so that is recommended, or you can say the provision is mandatory by the FRBM Act 2003. Okay, here you can see, according to article 112, we have already seen that president is required to lay the estimate of the receipts and the expenditure, that is there, that is generally called as the annual financial statement. Money bill is defined under article 110 clause 1. When we are talking about this particular thing, they are talking about the options as well. As I told you, when UPSC is giving you options, that does not mean that they are just giving you wrong options. They are giving you hints that they will be asking about that. That is why we have mentioned that what is article 112, we have mentioned what is article 110. Okay, we have mentioned what is article 113. So 113 is talking about this particular thing. This is the example, best example you can see. In 2024 they have given 2 statements over here. Now this statement is article 112. Okay, annual financial statement they are talking about. Wrong or right does not matter. They have made it wrong over here because this is not prime minister, that is president. But the thing is, they have asked article 112. In the second statement they have given article 113. Okay, now see, next year, here you can say 2020, they have last year, last to last year, when we talk about 2020, they have asked about all these things, article 112, 110, 113. Now if you are not doing this, see, FRBM Act also they have asked. So if they have actually given this hint, you should know about that. So they have given these hints in 2020, and in 2024 they have asked a question from that particular hint only. Okay, so that is why PYQ becomes important, and that is why we have precisely brought you this particular series. Okay, now let's see. So here we have already seen that is FRBM Act. Okay, coming to the Fiscal Responsibility and the Budget Management Act 2003 seeks to institutionalize financial discipline, reduce India's fiscal deficit, improve macroeconomic management and the overall management of the public funds by moving towards the balanced budget. Here you can say Act mandates. There are 3 documents which are being given over here. So next time, that is the hint for you, that which 3 documents are required by the FRBM, that can be asked by the UPSC. Okay, so here before the House of the Parliament, macroeconomic framework statement, that is 1, medium term fiscal policy statement and the fiscal policy strategy statement along with the annual financial statement and demand for the grant. So basically these are the 3 statements which are basically required by the FRBM Act to be submitted along with the budget. Okay, moving further, with reference to the Speaker of the Lok Sabha, consider the following statements. While any resolution for the removal of the Speaker of the Lok Sabha is under consideration, 3 statements are given. He or she shall not preside. Now that is correct. They should not preside. Then coming to the next one, he or she shall not have right to speak. Now that is not wrong. That is not right, because when we talk about right to speak, that is there with them. Okay, so that is wrong over here. He or she shall not be entitled to vote on the resolution in the first instance. Now since he is not presiding, that is why they can vote on the first instance. Okay, so that statement is also wrong. Option A is your right answer over here. Okay, so here Article 96 becomes important for you because that is talking about the speaker over here. At any sitting of the House of the People, while the resolution for the removal of the speaker from his office is under consideration, the speaker, or while any kind of resolution for the removal of the deputy speaker. So for speaker as well as for the deputy speaker, if there is a resolution at that point of time, they shall not preside the session over here. Okay, second thing is Article 95, if we talk about, that shall apply in relation to every such sitting as they apply in relation to the sitting of the speaker. Okay, so that is given over here. Coming to the 96 clause 2, which is talking about the speaker shall have right to speak. Okay, and that will be true for the, you can say, deputy speaker as well. Now in the first instance they will be having right to vote. Now they will not go for the tiebreaker. Speaker, when we talk about the parliamentary rules, etc., so you will be seeing that in Lok Sabha, speaker will not go for voting in the first sense. Okay, if there is a tie, in that case speaker will decide, and that will be the casting vote, but not vote in the first instance. But now since the resolution for removal is there, so he is acting as a normal member and he is not presiding officer, so in that case they have right to vote. Okay, so that is there. Coming to the next one, with reference to the Indian Parliament, consider the following statement: a bill pending in Lok Sabha lapse on its dissolution. Okay, a bill pending in Lok Sabha lapse on dissolution. Obviously that is correct. Okay, I'll give you a small, you can say, trick over here. That is, whenever there is a bill in consideration and we are talking about the resolution of Lok Sabha, whether it will lapse or not, so just know that if Lok Sabha has touched the bill, if they have touched the bill, that will lapse. Okay, but the thing is, there is one exception, that president has already announced his intention to summon a joint sitting. That is the only exception. Otherwise, let's just use this particular trick over here. A bill pending in Lok Sabha, that means that it has been into the Lok Sabha, that means that Lok Sabha has touched it, so it will lapse. Okay, coming to the next one, a bill passed by the Lok Sabha and pending in Rajya Sabha lapses on the dissolution of Lok Sabha. Passed by Lok Sabha, that means that Lok Sabha has touched it, so that will also lapse. So this is also correct. Okay, a bill in regard to which President of India has notified his or her intention to summon the House in the joint sitting lapses on the resolution. Now this is wrong because I told you there is only one exception. Okay, so that is the exception wherein President has already announced the intentions, and after that dissolution of Lok Sabha happens, so in that case bill will not lapse. Okay, so third one is wrong, 1 and 2 is correct. Option B would be the right answer. Let's see. Option B is your right answer. Now, it is this particular table. See, when we are talking about the resolution, so this is to end the life of a Lok Sabha. Okay, and this is only for Lok Sabha because Rajya Sabha does not get dissolved. Okay, so that is there. And who does that? By president or by the term, that is your 5 years, that is being finished, or you can say they have actually served for the term of 5 years, so it will automatically dissolve. Okay, so that is there. So there are two ways: either president can dissolve it, okay, on advice of the Council of Minister, or otherwise in certain cases himself also. Okay, now talking about the automatic, if they are finishing the term of 5 years, that will automatically dissolve. The termination of sitting, that will be when Lok Sabha is dissolving, that means that the sitting will be terminated, session will also be terminated, and life of Lok Sabha will also be terminated. Okay, now on the dissolution, what will impact, how it will impact the business of the House. So let's see. A bill which is pending at first House, that is Lok Sabha, will lapse because it has touched it. Then coming to the next one, bill pending at the first House, that is Rajya Sabha, will stay alive because it is still in the Rajya Sabha. Lok Sabha has not touched it, so it will stay alive. Coming to the next one, passed by the first House, that is Lok Sabha or Rajya Sabha. Any House has passed and the pending at the second House. So if passed by Lok Sabha, so Lok Sabha has touched it, or if passed by Rajya Sabha and pending in the Lok Sabha, so also Lok Sabha has touched it, so it will lapse. Okay, so that is also there. It reaches the president, pending for the assent, returns for the reconsideration, notified for the joint sitting. So it has reached to the president. If it has reached to the president, it will stay alive. Okay, so if president has touched it, it will stay alive. Then pending bills, assurances to be examined by the committee on the government assurance, this will be alive. Okay, a pending bill which is there, or assurance to be examined by the committee of the governance assurance, so such bill will be alive. Okay, so these are the two things, two exceptions are there. One is your president, second is the bill pending, and the assurance committee has some kind of something which is pending in the assurance committee, then it will be alive. Okay, so that is about the dissolution of the Lok Sabha. And when we talk about the prorogation or the, you can say, adjournment, so adjournment is basically the suspension of the work in a sitting. Okay, prorogation means that the postponement of the, you can say, session has been postponed to the next level. Okay, so here to postpone the session, that is budget, monsoon or winter. So when prorogation happens, that particular session comes to an hold. Okay, so that is there. Coming to the adjournment, again here it occurs at both Lok Sabha and Rajya Sabha. Every sitting is there, that will be adjourned. Okay, after that it will be adjourned by the presiding officer, that is either speaker or the chairman, the terminating the sitting of the Lok Sabha and Rajya Sabha. That sitting will be terminated, not the session. Then no effect on the pending business, because they will be coming to the next time and they will be talking about the same things. Coming to the prorogation, prorogation means that that particular session has ended, like budget session has prorogued, winter session prorogued, or monsoon session prorogued. So they will be meeting in the next session only. Okay, then when it will be summoned by the president. So when we talk about the summon and prorogation, that will be done by the president only and not by the speaker. Okay, so here you can say it occurs in both Lok Sabha and Rajya Sabha, and it will be by president and not by the speaker. Okay, termination of the sitting plus session, because that last sitting will be terminated as well as the session will also be terminated, not affect pending business or bills. They will actually be alive and they will be talking about that in the next session. All pending notices except for introducing the bill will lapse. Notice will be lapsing except for introduction of the bill. So this table becomes important for you. Again, if you want, you can take the screenshot of this particular table now. Okay, so now we can move further to the next one. With reference to the Parliament of India, consider the following statement. Prorogation of the House by the President of India does not require the advice of the Council of Ministers. Prorogation of a House by the President of India does not require the advice of the, you can say, Council of Ministers. Okay, we will hold on for this particular statement. Coming to the next one, prorogation of a House is generally done after the House is adjourned sine die, but there is no bar on the President to President of India proroguing the House which is in the session. Okay, so basically what they are saying is that once the House is adjourned, here we see that there is this adjournment which will be done by the speaker. Okay, now there is another term which is there, which is adjournment sine die. Now whenever there is an adjournment, speaker will tell next time we will be meeting on this particular day and time. Okay, but if speaker has not tell the day and time, that will be adjournment sine die. Okay, so date and time for the next sitting has not been given. Generally after adjournment sine die, 2 to 3 days, they will go, president will go for the prorogation. Okay, that is there. But it can be on the same day as well. It is not like that you have to do it after 2 or 3 days. It can be done on the same day as well. Okay, so that is the adjournment and the prorogation. So this statement is correct. Dissolution of the Lok Sabha is done by the President of India, who, save in exceptions and circumstances, does so on the advice of the Council of Ministers. Okay, fine. Dissolution is done by the on the aid and advice of the Council of Ministers, and then you can say in some cases where majority is not there, or you can say the government has fallen low confidence motion, in such cases they will be President will do it on his own as well. So this statement is correct. This statement is correct. Now coming to the first statement, prorogation of the House by the President of India does not require the advice of the Council of Ministers. For the prorogation and for the summoning the House, they require the, you can say, Council of Ministers advice, or Council of Ministers when we talk about, so basically that is your cabinet and prime minister. Okay, Council of Ministers when we see, so this is a broader term, Council of Ministers, under which there are some ministers which are quite important. Okay, they form the cabinet, and then we have prime minister over here. Okay, now there is this another term which is kitchen cabinet, that is even a smaller term. Along with prime minister, there are some important ministers like defense, or you can say finance, or the external affairs. They form the kitchen cabinet. This kitchen cabinet term was in you can say discussions during the time of Indira Gandhi. Okay, anyways, so this statement is the prorogation of the House of the President does not require the you can say advice. That is wrong. Okay, so 2 and 3 is correct. Option C would be your right answer over here. So Article 85 of the Constitution, which we have already talked about, that is talking about the power of President to summon the you can say House on prorogue this. So that is basically your Article 85, which we have already talked about earlier. Coming to the next one, so again you can see they have asked a question from the Article 85 again. So now this from the core area. What is the core? Article 110, Article 85, and when we talk about Article 117, 13, these are some of the articles which are being asked again and again. Okay. Now, the President exercises the power to summon and prorogue the House on the recommendation of the Prime Minister and the Cabinet, or basically you can say the Council of Ministers. Okay, so that is the first statement is wrong. Prorogation we have already talked about. Adjournment I told you. Adjournment sine die I told you, and dissolution of the House I told you. Okay, now let's move further. Over here also, in India, Lok Sabha has 5-year term, which we have discussed. Okay, but it can be dissolved earlier as well. Article 83 clause 2 of the Constitution, completion of the 5 years from the first day of the meeting automatically dissolves the Lok Sabha. Okay, so that is there. Lower house can also be dissolved earlier by the president on the advice of prime minister. It can also dissolve if the president feels that no viable government can be formed after the resignation or the fall of the regime. Okay, so that is the discretion of the president. Okay, most of the time you will be saying that president does not have much discretions. Okay, but sometimes he has. Okay. Now, before moving further, we have IAS Prelims course for you, that is GS plus CSET online course will be there. If we talk about the key features, 500 plus hours of the classes will be there, unlimited watch time. So, if you take the course for the validity of the course, you will have unlimited watch time. You can watch a particular video as many number of time if you want. Okay, so that will be very beneficial for your revisions as well. And then 30 free test will be there for GS and the CSET. Okay. Now, for more details, you can call on this number, that is 87501 87501, or you can download the Drishti learning app. Okay. Now, moving further, which of the following is or are the exclusive power of the Lok Sabha? To ratify the declaration of emergency. Coming to the next one, to pass a motion of the no confidence against the Council of Ministers to impeach the President of India. Now, if you want to know about the impeachment of the President, so for that, both Lok Sabha and Rajya Sabha has the same kind of power. When we talk about the ratification of the emergency, so that is not an exclusive power of Lok Sabha. If Lok Sabha is dissolved or it is not in session, in that point of time, you can say Rajya Sabha can approve the declaration. So that is not exclusive power of Lok Sabha. Coming to the passing of the no confidence motion, here you can say that is only an exclusive power of Lok Sabha, because Council of Ministers is collectively responsible to the Lok Sabha. Okay, so that is there. And the impeachment also, the Rajya Sabha has a role, so only 2 would be your right answer, option B. Okay, so you can go through this when we talk about the impeachment of the president, that becomes important, so go through that particular procedure as well. Okay, so that is about it. Now, moving further, when we talk about the impeachment procedure, you know that there is a special majority which is required, that is special majority of 2/3 of the people who are present and voting, and half of those who are basically you can say total membership. Okay, so that is basically your you can say impeachment, particularly when we talk about the impeachment of the president. When we talk about the constitution, there is only impeachment of president. Other than that, when we talk about the judges and the judges of Supreme Court and the High Court, there is the impeachment like procedure. Generally it is called as the removal of the judges and by a impeachment like procedure. Okay, so that is there. Moving further, Rajya Sabha has equal powers with Lok Sabha. In what matters Rajya Sabha has equal power? One time they have asked about the exclusive powers of the Lok Sabha. In the next time they have talked about the, in the last to last time they have talked about the powers of the Rajya Sabha and Lok Sabha. The matter of creating new All India services. Now Rajya Sabha has equal power. Now that is special power of Rajya Sabha. Okay, special power, because Rajya Sabha will initiate the proceedings. Okay, coming to the next one, amending the constitution, both Rajya Sabha and the Lok Sabha has the same power, so we can say that option B we can consider. Coming to the next, removal of the government, that is exclusive power of Lok Sabha. Okay, making cut motion, that is also exclusive power of Lok Sabha. Okay, option B would be your right answer, which we have already discussed. Okay. Now there are some article which is important, that's article 249, power to transfer subject from state list to union list. That is a specific power of Rajya Sabha. The Rajya Sabha has some 3 powers which is specific to Rajya Sabha. Okay, that is one which is given in article 249, and second is article 312. Okay, that is creation of all India service. Okay, to endorse emergency under article 352 for a limited period when Lok Sabha remains dissolved. Okay, so that is also you can say special power. So these are the 3 special power. Then other than that, when we talk about some of the aspects where both of them are having equal powers, so here you can see other important matters with respect to which both houses enjoy equal powers are basically election and the impeachment of the president, election of vice president, amending the constitution, approving the proclamation of the emergency, the proclamation regarding the failure of the constitutional machinery in the states, and the financial emergency. Okay, now Council of Ministers, I told you that is collectively responsible to the you can say Lok Sabha. Cut motion, when we talk about, that is special power which is vested in Lok Sabha. Okay, that is with respect to the demand of the grants, etc. So that kind of power are with the Lok Sabha. Consider the following statement: if the election of the President of India is declared void by the Supreme Court of India, all acts done by him or her in the performance of the duties of his or her office of the President before the date of the decision becomes invalid. Now that is not true. If he has taken the decision before the you can say the removal, okay, if the election has been termed as void and then he is again removed, so in that case whatever decision he has taken, that will remain valid, because he was president for a time. So to maintain the sanctity of the post, we are saying that that will stay valid. So this statement becomes incorrect. Election for the post of President of India can be postponed on the ground of some legislative assemblies has been dissolved. Now, when we talk about some legislative assemblies has been dissolved and elections are yet to take place, in such cases, you cannot postpone the election of president. So that is incorrect. Okay. When a bill is presented to the President of India, the Constitution prescribed time limits within which he or she has to declare his assent. Now, that is also not true. There is no such time period. Okay. So option D would be your right answer. That is none. You can go through this particular thing because we have actually discussed the statements over here. Coming to the next one, we have talked about the president over here. We have talked about the some of the power with respect to the you can say Rajya Sabha, etc. And now comes the next topic, that is your president. So we have taken the question over here. These are some of the aspects of the president, okay, like who is the president, what are the important articles which are there with respect to the president, and then what are the powers he has. This is basically a static part, so I'm not going into it. I have kept it over here, so you can take the screenshot and you can actually go through it on your own. Okay, now let's move further. Consider the following statement. The Constitution of India classifies the ministers into 4 ranks. Okay, now there are only 3 ranks which is there, so that is, you can say this statement is incorrect. Total number of the ministers in the union government, including the prime minister, shall not exceed 15% of the total number of the ministers in the Lok Sabha. So that member in the Lok Sabha. So that is correct. So option B would be your right answer over here. So option B is there. There are 3 categories of the minister which are there in one in the Council of Ministers. One is cabinet minister, then minister of state, and deputy ministers. Okay, and there is a difference between their hierarchy, etc., and on the basis of which they have actually 3 different you can say categories. The next is total number of membership of the Council of Ministers. That should be 15% of the total membership of Lok Sabha, which we have already discussed over here. Now let's move further. Consider the following statements. The Parliament Prevention of Disqualification Act 1959 exempts several posts from disqualification on the ground of office of profit. Okay, you can know this or you might not know this. Coming to the next one, the above mentioned act was amended 5 times. Now, how will you know that act was amended how many times and how many acts you should remember? Now, the thing is, it has been there in the, you can say, current affairs, okay, in way back in 2018-19. But the thing is, if you look at this particular question, you will be seeing that how I will know that which act is amended 5 times. But don't lose hope, just go through all the statements. Now, the term office of profit is well defined in the Constitution of India. I told you, like, you know, few slides ahead, I told you that office of profit is not defined in Constitution of India. Now, if you eliminate this particular option, you will be finding that 3 is eliminated. So all the options becomes wrong. Only option A and B is wrong. Both the statement here are correct. But the thing is, only you will know if you know this particular statement. Okay, either if you know all the statement, that is well and good, but if you know this much, because that is basic, that is expected from you to know. So if you know this, that means that you will be able to solve this question. Okay, now coming to the next one. So, the Parliament Prevention of the Disqualification Act 1959 exempts several posts from the disqualification, that is Minister of State and Deputy Minister, Parliamentary Secretaries and Parliamentary Under Secretaries, Deputy Chief Whips. You can go through this particular list. Okay, so statement 1 is correct. Now, that act has been amended 5 times, which has been given over here: 1960, 1992, 93, 2006 and 2013. And when we talk about the Constitution of India, it does not clearly define what constitutes the office of profit, but defines but the definition has evolved over the years with the interpretation from the judiciary. Okay, so that is what has been discussed over here. Now let's see which of the following statement about the ethics committee in the Lok Sabha are correct. Now the problem is that when we talk about the article, when we talk about the parliamentary committees, there are various committees. Now, how many of you should remember? Obviously, all of them. These all of them are important, but the problem, but the thing is that which is in the news, which, if let's say if there is a parliamentary committee which has been in the news, then it becomes imperative for you to know about that particular thing in detail. Okay, so when we talk about the ethics committee in 2023-24, you must have heard about a case, that is Mahua Moitra case, which has happened, and the cash for query in the parliament, that particular term was in discussion, and that issue has been referred to the ethics committee, and that is why they have asked a question from the ethics committee. Now this year, recently, Public Accounts Committee has been in the news. So now it is your duty to read about the Public Accounts Committee. Okay, now let's see. Initially, it was an ad hoc committee. That is correct. Only a member of the Lok Sabha can make the complaint relating to the unethical conduct of the members of the Lok Sabha. Now, this is incorrect. Any person can make such complaints, but he should have a, you can say, legal practitioner along with him. So that is there. Any person, a normal person also can make a complaint like that. So statement 2 becomes incorrect. So if you remove the 2, you will be coming to an answer that is option C. This committee cannot take up any matter which is sub judice. Sub judice means that if there is a matter which is already in the court, okay, so that this committee cannot take up, okay. So 1 and 3 is your right answer. Option C is your right answer. If you talk about the ethics committee, it is constituted in Rajya Sabha in 1997 and Lok Sabha in 2000. The code, it actually basically enforced the code of conduct of the members of the parliament. It examines the case of the misconduct, recommendation, appropriate actions, maintaining the disciplines and the decorum in the parliament. This is normal. Ethics committee was constituted as the ad hoc committee in 2000 and then it was made permanent only in 2015, okay. So now we can move further. This is the procedure of complaint. You can go through this. So here initially there was a provision that you can say there was this rule of ethics committee that allowed any Indian citizen to file a complaint against the lawmaker, okay. But then there was this particular thing that it can go against the rivals as well. So ultimately there was this you can say provision which was made that that particular person should have a you can say legal you can say lawmaker with him, okay, along through a lawmaker. So basically that person has to make a complaint through a lawmaker only. So the rule was then modified to the extent that the complaint had to be submitted in the panel through a lawmaker. So basically any person can make the complaint, but submission of the complaint will be through the lawmaker only, okay. So that is there. Coming to the next part. In India, which of the following review the independent regulators in sectors like telecommunication, insurance and the electricity? Ad hoc committee set up by the parliament, okay, that they can do. Parliamentary departmental related standing committee, they can also do that. Finance commission does not have such role. Finance commission will do the job related to the sharing the revenue between states and the you can say center, that is there. Other than that, they can make recommendation for the financial prudence, but not like this, okay. Financial sector legislative reforms commission, okay, so that is also not true. And Niti Aayog is also not there. So if you can look this particular, if you know that 1 and 2 is your correct options, so here only option A is your right answer, okay. So that is there. When we talk about the parliamentary committees, there are two kind of parliamentary committees. One is the standing committee, second is ad hoc. Standing committees are those which are having being elected every year, and when we talk about the ad hoc committees, they will be elected for a particular work, for a particular job, okay. So that is there. Right now in India there are 24 department related parliamentary standing committees which are there, okay. Ad hoc committees, I told you, they are basically set up for to examining the working of the regulators, and for instance they will be there for a particular time, okay. So that is there. Coming to the role of finance commission and the Niti Aayog is advisory in nature and they do not review the independent regulators, which I have already told you. Now coming to the next part, that is considering the following statement. Attorney General of India and the Solicitor General of India are the only officers of the Government of India who are allowed to participate in the meetings of the Parliament. Only Attorney General of India is allowed and not Solicitor Generals, okay. So this statement becomes incorrect. According to the Constitution of India, Attorney General of India submits his resignation when the Government of India to the government which appointed him resigns, okay. So basically they are saying that when there is a you can say resignation, he will be submitting the resignation when the government which has appointed has actually resigned. So that is there. So here you can see option D is your right answer, because considering this particular statement, if we talk about, so that is also wrong, because when we talk about the appointment of the Attorney General of India, that is basically is on the pleasure of president, okay. So that resignation will be also directed to the president over here, okay. So that is there. Option D would be a right answer, because both the statements are wrong, okay. So here you can see Constitution does not mention the Solicitor General and the additional Solicitor General, that is there. And coming to the next part over here, according to the Constitution, only Attorney General take part in the proceedings of the both houses of the Parliament or any kind of joint sitting and any committee of the Parliament which is there, and he does not have a right to vote over here. He can only, you can say, be part of it, okay. Coming to the next one, the procedure and the grounds for the removal of the Attorney General are not mentioned in the Constitution, and he hold office during the pleasure of the president only. And when we talk about, therefore the Attorney General does not resign on the resignation of the government, okay. So that is that he will resign on his own, or he will be removed by the president, okay. So that is why this statement 2 is incorrect. Now coming to the next part, before that we are offering IAS Prelims 2025 course over here for the general science over here. Key features are given over here, 400 plus hours of the classes, unlimited view time, prelim test series will also be there. For more details you can call on this particular number, that is 87501 87501, or you can download the Drishti learning app. Now let's come to the next part, that is state and the executive legislature, okay. It is the governor of the state who recognizes and declares any community of that particular state as a scheduled tribe. No, that is not governor, this is basically president, okay, not governor. A community declared as a scheduled tribe in one state need not to be so in other states. So in different states, different communities can be, you can say, scheduled tribe. And if there is a community which is a scheduled tribe in let's say Rajasthan, that cannot be a scheduled tribe in Gujarat, okay. So that is not necessarily you can say it can be there. So statement 2 is correct. A community declared as scheduled tribe in one state need not necessarily be scheduled tribe in another state, okay. So statement 2 is correct, and option B would be a right answer. So Constitution of India, Article 366, Clause 25 prescribes that the scheduled tribe means such tribes or tribal communities as are deemed under Article 342 of the Constitution of Constitution to be scheduled tribes. So basically, if in this particular you can say article, if you have actually said that this particular community is scheduled tribe, that will be considered as a scheduled tribe. Article 342 Clause 1, that is president with respect to any state, okay, after consultation with the governor in case of the state, may specify the tribal communities, part of the groups or the the whole community or the part of that particular community and the tribal communities as the scheduled tribe. So basically president has that particular right, okay. The list of scheduled tribe is the state or the UT specific. A community declared as scheduled tribe in a state need not to be a scheduled tribe in the other state, okay. Now we have talked about the president, and here was the mention of the governor. So what I have done is that I have put some part of the static revision which is there. So you can go through this, you can take a screenshot over here. So there is some specific things like the eligibility criteria, the appointment and the tenure, powers of the governor, dual capacity, or you can say tenure, all these things are given over here. Other than that, here you can see some of the similarities between the governor and the president has been given over here, and some of the differences has been given over here, okay, because UPSC has tendency to ask such questions because they have, see, here they have asked this question because there is a intricacy between the you can say making that particular list by the president or the governor. So that is why they have asked about it. One more question we will be seeing over here. Let's see. With reference to the scheduled area in the India, consider the following statement. Within a state, notification of an area, a scheduled area, take place through the order of the president. Okay, so that is one thing. Coming to the next one. Now, who does that? Whether it will be done by the president or the, you can say, governor. So that is why these kind of you can say differences and the similarities becomes important. Okay, the largest administrative unit forming the scheduled area is the district, and the lowest is the cluster of the villages in the block. So this statement is correct. The chief ministers of the concerned state are required to submit annual reports to the union home ministries. Now these are not chief ministers, basically governor will be reporting to the president. Now if you know if this or this, both of them are wrong, so you can see that you can eliminate this particular options easily. So this becomes wrong, so only two, option B would be a right answer, first one and the second one. So when we talk about the scheduled areas or the scheduled tribes, that will be notified by the president, okay. So option B is your right answer, that is over here. You can go through this because we have already discussed that, okay. Now coming to the next one, with reference to the Legislative Assembly of State in India, consider the following. The governor makes a customary address to members of the House at the commencement of the first session. This is right. Even president do the same thing. So that is why it is the similarity. Okay. Coming to the next one, when a state legislature does not have a rule on a particular matter, it follows the Lok Sabha rule. That is also right. So if a state legislature does not have a rule on a particular matter, they will follow the rules of the proceedings of the Lok Sabha. Okay. So option C would be your right answer over here. Now let's move further. Article 176 clause 1. Now please remember that they have asked about the provisions. Okay, so there are high chances that they might ask about the articles next time, because that has the same thing has happened when in 2020 they have asked about the provisions, and in 2023 they have, or 2023 or 24 they have asked about the articles. So now they have asked about the provisions over here, they might ask you about the articles. So article is 176 and article 208 which has been given over here. Now let's move further. Union state relations. Which one of the following in Indian polity is essential features that indicates that it is federal character? Okay, they are talking about the federal character over here. Independence of judiciary is safeguarded. So this is a federal character, I would say. Okay, but the thing is, let's read the options as well. The union legislature has elected representatives from the constituent units. Now that is more of a republic in nature, okay, and not or representative government in nature, and not basically you can say federal feature. Okay, so this statement is incorrect. 1 is the right answer over here. Coming to the next statements over here or the options, the Union Cabinet have elected representatives from the regional parties. That is not sure, not only from the regional parties, that can also be different. Okay, then fundamental rights are enforced by the court of law. Okay, now this particular feature, this is true when we talk about the features which is given over here. The statement is true, but the thing is that is not, federal feature. So this is with respect to liberty, you can say, with respect to justice, with respect to equality, you can say that statement is true. But when we talk about the federal character, independence of the judiciary is your federal character. So there are some federal characters which has been given over here. Federalism, when we talk about, it is a system of government in which the power is divided between the central authority and the constituent units. So that is there. And different sets of the government with divided subjects of power and independent judiciary is a vital feature of the federal system. Independent judiciary is the core feature of the federal system. The Indian Constitution has enshrined independence of the judiciary through number of measures. That is, legislature is not much involved in the process of the appointment of judge. So here you can say, in the process of appointment of judge, executive and the judiciary is responsible, and judiciary has a upper hand over there. Coming to the next one, judges have a fixed tenure. Difficult procedure for the removal of the judges because the special majority is required, like which is required for the president. So that is why you can say that as well. Then some other federal features, that is written constitution, rigidity of the constitution, supremacy of the constitution, dual polity constituting the union at the center and the states at the periphery, and the division of power between center and the state by the schedule 7. We have 3 lists which we have already seen in the episode 1. Okay, so that is about basically your federal features. Okay, so in today's episode we will be talking about this much only. Here we are also having ISGS foundation course for you, wherein 1000+ hours of the classes are there, unlimited view times will be there, and the prelims test series will also be included in the course over here. So you can call on this number, that is 87501 for more details. So this is about the ISGS foundation course that will help you prepare for the UPSC prelims as well as mains. Okay, now with that we will be taking your leave. We will see you in the next episode, and don't forget to answer the mock question which is given in the comment box. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.